Code of the District of Columbia. Section 28:4A-107. Federal Reserve Regulations and Operating Circulars. Regulations of the Board of Governors of the Federal Reserve System and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of this article. To the extent of the inconsistency, April 30, 1992, D.C. Law 9-95, Section 2C, 39 DCR 1595. Prior codifications 1981 ed., Section 28:4A-107. Uniform Commercial Code Comment 1. Funds transfers under Article 4A may be made, in whole or in part, by payment orders through a Federal Reserve Bank in what is usually referred to as a transfer by Fedwire. If Bank A, which has an account in Federal Reserve Bank X, wants to pay $1 million to Bank B, which has an account in Federal Reserve Bank Y, Bank A can issue an instruction to Reserve Bank X requesting a debit of $1 million to Bank A's reserve account and an equal credit to Bank B's reserve account. Reserve Bank X will debit Bank A's account and will credit the account of Reserve Bank E. Reserve Bank X will issue an instruction to Reserve Bank Y requesting a debit of $1 million to the account of Reserve Bank X and an equal credit to Bank B's account, and Reserve Bank E. Reserve Bank Y will make the requested debit and credit and will give Bank B an advice of credit. The definition of bank in Section 4A-105A, 2, includes both Reserve Bank X and Reserve Bank E. Bank A's instruction to Reserve Bank X to pay money to Bank B as a payment order under Section 4A-103A, 1. Bank A is the sender and Reserve Bank X is the receiving bank. Bank B is the beneficiary of Bank A's order and of the funds transfer. Bank A is the originator of the funds transfer and is also the originator's bank. Section 4A-104C and D. Reserve Bank X, an intermediary bank under Section 4A-104B, executes Bank A's order by sending a payment order to Reserve Bank Y instructing that bank to credit the Federal Reserve account of Bank B. Reserve Bank Y is the beneficiary's bank. Suppose the transfer of funds from Bank A to Bank B is part of a larger transaction in which originator, a customer of Bank A, wants to pay beneficiary, a customer of Bank B. Originator issues a payment order to Bank A to pay $1 million to the account of beneficiary in Bank B. Bank A may execute originator's order by means of Fedwire, which simultaneously transfers $1 million from Bank A to Bank B and carries a message instructing Bank B to pay $1 million to the account of Y. The Fedwire transfer is carried out as described in the previous paragraph, except that the beneficiary of the funds transfer is beneficiary rather than Bank B. Reserve Bank X and Reserve Bank Y are intermediary banks. When Reserve Bank Y advises Bank B of the credit to its Federal Reserve account, it will also instruct Bank B to pay to the account of beneficiary. The instruction is a payment order to Bank B, which is the beneficiary's bank. When Reserve Bank Y advises Bank B of the credit to its Federal Reserve account, Bank B receives payment of the payment order issued to it by Reserve Bank E. Section 4A-403A, 1. The payment order is automatically accepted by Bank B at the time it receives the payment order of Reserve Bank E. Section 4A-209B, 2. At the time of acceptance by Bank B, payment by originator to beneficiary also occurs. Thus, in a Fedwire transfer, payment to the beneficiary's bank, acceptance by the beneficiary's bank and payment by the originator to the beneficiary all occur simultaneously by operation of law at the time the payment order to the beneficiary's bank is received. If originator orders payment to the account of beneficiary in Bank C rather than Bank B, the analysis is somewhat modified. Bank A may not have any relationship with Bank C and may not be able to make payment directly to Bank C. In that case, Bank A could send a Fedwire instructing Bank B to instruct Bank C to pay beneficiary. The analysis is the same as the previous case except that Bank B is an intermediary bank and Bank C is the beneficiary's bank. 2. A funds transfer can also be made through a Federal Reserve Bank in an automated clearinghouse transaction. In a typical case, originator instructs originator's bank to pay to the account of beneficiary in beneficiary's bank. Originator's instruction to pay a particular beneficiary is transmitted to originator's bank along with many other instructions for payment to other beneficiaries by many different beneficiaries' banks. All of these instructions are contained in a magnetic tape or other electronic device. Transmission of instructions to the various beneficiaries' banks requires that originator's instructions be processed and repackaged with instructions of other originators so that all instructions to a particular beneficiary's bank are transmitted together to that bank. The repackaging is done in processing centers usually referred to as automated clearinghouses. Automated clearinghouses are operated either by Federal Reserve banks or by other associations of banks. If originator's bank chooses to execute originator's instructions by transmitting them to a Federal Reserve Bank for processing by the Federal Reserve Bank, the transmission to the Federal Reserve Bank results in the issuance of payment orders by originator's bank to the Federal Reserve Bank, which is an intermediary bank. Processing by the Federal Reserve Bank will result in the issuance of payment orders by the Federal Reserve Bank to beneficiaries' bank as well as payment orders to other beneficiaries' banks making payments to carry out originator's instructions. 3. Although the terms of Article 4A apply to funds transfers involving Federal Reserve banks, federal preemption would make ineffective any Article 4A provision that conflicts with federal law. The payments activities of the Federal Reserve banks are governed by regulations of the Federal Reserve Board and by operating circulars issued by the reserve banks themselves. In some instances, the operating circulars are issued pursuant to a Federal Reserve Board regulation. In other cases, the Reserve Bank issues the operating circular under its own authority under the Federal Reserve Act, subject to review by the Federal Reserve Board. Section 4A-107 states that Federal Reserve Board regulations and operating circulars of the Federal Reserve Bank supersede any inconsistent provision of Article 4A to the extent of the inconsistency. Federal Reserve Board regulations, being valid exercises of regulatory authority pursuant to a federal statute, take precedence over state law if there is an inconsistency. Childs v. Federal Reserve Bank of Dallas, 719 F.2d 812, 5th Sir. 1983, Ray, Den. 724 F.2d 127, 5th Sir. 1984. Section 4A-107 treats operating circulars as having the same effect whether issued under the Reserve Bank's own authority or under a Federal Reserve Board regulation. Publication information current through September 6, 2023. Last codified D.C. Law. Law 25 to 50 effective September 6, 2023. Last codified emergency law, Act 25 to 215 effective August 2, 2023. Last codified federal law, Public Law 115 to 334 approved December 20, 2018. The codes and laws on this website are in the public domain. Please do not scrape. Instead, bulk download the HTML, https://github.com/council/law HTML, or XML, https://github.com/council/law XML, powered by the nonprofit Open Law Library, http://www.openlawlib.org/